Welcome to the City of Larkspur and the Town of Corte Madera Shared Fire Services Ad Hoc Committee meeting at Larkspur City Hall on July 24th, 2017. I'd like to welcome our colleagues and friends, Diane First and Sloan Bailey from Corte Madera and Larry Chu from Larkspur. So we'll begin by having welcome and introductions. I think I just did those. Anyone else have any introductions they'd like to do? I want to introduce staff.
Well, I'm Dan Schwartz. I'm the city manager for the city of Larkspur.
Todd Cusimano, the town manager of Corte Madera.
Tom Bertrand, outside legal counsel, who drafted the draft JPA agreement.
Scott Schertz, fire chief.
Rebecca Vaughn, town clerk for Corte Madera.
Nick Gabbard, Captain, Corte Madera Fire Department.
Terrific. And I'd also like to acknowledge Kevin Haroff, the mayor from Larkspur, and Jim Andrews, council member from the town of Corte Madera, also with us, and three of our fire professionals. Saying thank you very much for being here. Second on the agenda is open time for public expression. Is there anyone from the audience who'd like to address these council members on an item not on the agenda tonight? All right, seeing none, we'll go to number 3, the manager's update.
I just wanted to let the council members know that tomorrow I'll be meeting with LAFCA and finding out how they want to implement their new policy as it applies to the consolidation. And once we have assessment of that, we'll put out a memo summarizing how we're going to move forward.
Great. Anything, Todd?
No.
Okay. Any questions of the managers on that issue? No? Number 4 is the fire chief update.
I actually prepared a few comments that I just wanted to
Do you have a PowerPoint?
address. I do not.
Because it usually breaks down around this office.
Good evening. You might. I'm sorry. Good evening. We've run well over 4,000 calls for service since we began operating as one. There is absolutely no doubt that we are more effective operating as a single agency. Operational roles are more clearly defined. Staff now have an increased familiarity with additional equipment and with the specific unique challenges of each fire protection zone. Staffing depth and flexibility have been enhanced, creating fewer forced overtime shifts. Opportunities for mentorship and quality of training have been enhanced due to an increase in the amount of in-house subject matter expertise. The commitment to dedicated battalion chiefs has enhanced firefighter safety and has significantly increased the organization's internal command and control capabilities. Within the next few weeks, we will have a dedicated fire marshal who will bring innovation and focus to our fire prevention and public education programs. And morale continues to be high with the prospect of making permanent these improvements to our capabilities through a more formalized commitment such as the one we're discussing this evening. On a personal note, I just want to publicly acknowledge how impressive it has been to watch our fire department professionals not only accept a highly unusual set of circumstances, but actually embrace them. The blending of these two organizations has challenged all of us. But over the last year and a half, the firefighters have truly demonstrated all the qualities that we've come to expect from our emergency responders. Effort, persistence, the ability to adapt and overcome challenges and setbacks, and the creativity to seek and discover solutions to unusual problems. But most impressive to me has been the trust that was formed and demonstrated by all involved. What we're trying to do says a lot about the personnel, the elected officials that guide them, and the communities they serve. Success requires energy, vision, planning, and execution, but I believe trust is the key ingredient that makes everything possible. And I want to thank the fire personnel for demonstrating trust in all of us. And of course, thank you, the two councils, for showing your trust in staff, which has allowed us to get to this exciting point in the history of these two great communities. We are all looking forward to the transition to the Central Marin Fire in the very near future.
Thank you, Chief. Do you have any questions that council members have of the Chief's report? Thank you very much. This brings us to number 5, the review and possible direction regarding the draft Joint Powers Authority JPA agreement. And everyone should have had that sent to them by Rebecca. Thank you very much. And there's also copies of the draft on the back table for those of you who would like to read along. Who's going to present this?
Thank you. I'd like to start off and introduce again Tom Bertrand. He needs no introduction to the ad hoc committee, but he is the Central Marin Police Authority's legal counsel. He drafted this draft JPA agreement, and in a second I'm going to ask him to go over the high points and answer any questions that you may have. This agreement should look familiar to those that have served on the Police Council, as Tom was the author of not only the Twin Cities Police Authority JPA, but the Central Marin Police Authority JPA. And really the four corners of this JPA does follow many similarities to those two agreements. And with that, I'll turn it over to Tom.
Thank you, Todd, very much, and thank you for the opportunity to appear this evening and present the JPA agreement. Todd is exactly right that this new fire authority has the benefit of the police authority. I've practiced law for 45 years. The police authority has been around a long time, and I think through some trial and not necessarily a lot of error, we have a very good JPA agreement. It works very well. We haven't had many problems at all. This particular draft agreement is closely patterned after the Twin Cities and Central Marin agreement. Probably one of the biggest problems facing us in Central Marin and facing you now is what you're going to call this fire authority, the name. And believe me, we struggled and struggled and struggled with the police department. We struggled in two respects. The first half of the name, which was Central Marin, some of us didn't like that. We tried all kinds of different variations, from Mount Tam to Bayside to Tri-Cities to anything and everything you can think of. And we chose Central Marin because it probably was most descriptive of where we were geographically and what we were trying to do. The next thing was, are we going to call ourselves a police department or a police authority? You have the same thing going on here. I wanted to just give you the benefit of the legal nuances of the difference between an authority and a department, and I also want to give you my recommendation that you not call this authority a department, and the reasons why. I realize the strong feelings on everybody's part and the preference for a department or the name of a department. But a department under the law is really a subdivision of a municipality. That's its legal definition. And it cannot be sued in its own name. A department does not exist separately from a municipality. And it's a big misnomer, and it's a confusion to call this a department. And by this, I mean the authority. What you're doing is making a significant structural change from a department or two departments, which are the subdivision of the municipalities, and transmuting that and changing that to a standalone joint powers public entity. And it's going to create real confusion there's a very specific meaning attributed to the department. Now, the biggest comment I get is, well, Ross Valley did it, and Ross Valley calls itself a fire department. Why can't we? I took the liberty with Todd's agreement of forwarding this to the Ross Valley's original author of their agreement. And it's a union attorney by the name of John Gray, who's been very helpful to us here. But just ask him to look at the agreement structure-wise. And the union doesn't have much to do really with the structure of this agreement. This is really structural. When you're talking about operational consolidation, you're talking about an MOU with the union to cover day-to-day operational activities. This particular document is a structural or legal form of the entity that you're dealing with. So knowing John quite well, I asked him, well, did that question come up in Ross Valley, and how did you deal with it, and what was done there? John's response, a very honest one, was, well, we never really discussed it. All the guys wanted to call it a department, so we called it a department. I said, well, how did you get past the Secretary of State, and how do you avoid confusion in terms of labeling it a department? And he said, well, honestly, we're halfway pregnant. With the agreement, if you look at the agreement, it's called Fire Authority, but we will be known as a fire department, and we kind of bounce back and forth between the two. That's not the way that I would recommend you go about this. My clients don't always follow my advice. Usually they do, but sometimes they don't. The police authority, we kick that around. Nobody really likes authority. You maybe could call yourself something different, just not department. It's like mixing up the two emblems on a car. If you were going down the freeway and you saw a Mercedes emblem on a BMW or something like that, it's a misnomer, and it's not legally correct, and it's going to lead to confusion. So that's my legal recommendation, and you make the decision, not me. I'm not driving this. I give you my advice and recommendation, and I'll forever hold my peace on that. And you give me direction, and the managers can give me direction with everybody's input on what you want to do there. The agreement is pretty straightforward. If you've had an opportunity, you can take the time to look at it. There's different ways you can do this. There's a district, and I represent the fire department districts in the county. I represent about 60 different public entities altogether in Northern California, and they do take different forms or changes. But this, of course, is really geared towards governance by the councils, the elected representatives of the councils, as opposed to a district board or something, some other form. The voting requirements, the powers and duties of the authority are pretty straightforward. The personnel, the management committee obviously runs the authority from day to day. I would make a comment about a legal advisor. You don't want one of your town or city attorneys to be your legal advisor. The legal advisor owes his or her allegiance to the authority. And with the police authority, with some luck, I've managed to, over the many decades, tiptoe through the tulips, if you will, and not take one side or the other. I avoid that like the plague. It's not the role of the legal advisor to take one member's side over the other. I was trying to think over the weekend, have we ever had a real push or shove with the police authority on one side being favored or feeling they were being favored? We had one problem, a financial problem, many, many years ago. I refused to give advice to either side and suggested that the two members go to mediation. So we took council members, we went to a mediation, had an outside mediator help the council members, and we resolved the problem without too much fuss, and it was pretty good. On that same note, I'd just like to jump ahead to the dispute resolution process at the end of the agreement.
Tom, could you mention what page number that is?
Yes, it's page 16 and it's section 15.
Okay.
So if something comes up where the two sides or two members cannot agree, there's a very clear and very definite dispute resolution process, which does not contemplate litigation. One party can get an injunction to maintain the status quo, but that's it. There's mediation as a first step, and it's mandatory mediation. There is then arbitration, which is binding arbitration. There's no lawsuit, and there's no recovery of attorney's fees. And that is to fulfill the express intention of, if any legal dispute arises, that dispute will be resolved as quickly, as cheaply, and as easily as possible. And those are the two methods. Now, we've never invoked that with the police authority. I've used it with other public entities, and it works pretty good. Back to cost sharing, the formula I think you're all familiar with. The fire station ownership, just really briefly, you're all familiar with the structures. You maintain your own, that's an incorrect word. You own your own fire stations, maintain the ownership, but and you also maintain it, but the authority is going to lease, typically for $4 a year, lease the 4 stations. The maintenance is covered, insurance, existing equipment obligations is pretty straightforward. The transition provisions, we're lucky, I think, in that the associations in this proposed marriage are doing a terrific job of cooperating and giving. And in speaking with Mr. Gray, the union attorney this weekend, he told me, I am committed to delivering a 3-year MOU that gives the authority the very best chance of having a smooth transition. It's been my experience that probably the most fragile time period for this authority is at its inception and maybe the first couple of years. And having that type of commitment by the Unions Council is terrific. Mr. Gray is a firm, true believer in consolidation. If he had his way, there'd be one big consolidated fire department in Marin County. So that's fortunate, that's helpful. And this transition agreement will be very important. It's not something that you really want to cover in your structural agreement. That'll be in the MOU, the terms of the transition. There's the coverage of OPEB benefits and pre-existing side funds. John Gray had one suggestion, which I don't see that much of a problem with or change to the agreement before you, and that's on page 14. It's subsection D. He said, Tom, I read that. I know what you're trying to say there, but can we, because you have the preceding section and you have what happens on termination in 14.4, can we just drop that? I'll take that up with the managers. I don't have a problem with it.
You're talking about the one titled Obligations for Future Payments
Yes,
for
ma'am.
previously? Okay.
Yes, ma'am. This brings us pretty much to PERS, and Todd and I originally, and Dan, had this agreement and start date as September 1st. And if ever there was a swamp that existed in California, it's PERS. And they're slow, they're unwieldy, they're full of bureaucracy and regulations.
Tell us how you really feel.
Yeah. And if you call them up, they're like the IRS, depends on who you get 10 different answers to the same question. However, it's very clear we need this agreement approved by PERS. And PERS is most interested at this point in time in the paragraph on page 15, 14.4, which is what happens if the authority goes kaput. you guys don't like each other, or you get a divorce, and what's going to be the plan for all the benefit plans and the CalPERS retirement stuff. They like to see that in a JPA agreement, if it's terminated and dissolved and no longer exists, you really can have a couple things happen. You could have a county-wide fire department, and in who knows when, this JPA might be consumed or subsumed into that, and it would take over the agreement. But the real possibility is the one we've covered for here, which is the obligation for the pension payments is going to revert back to the members. And it's going to revert back under the formula and the percentage share that's provided for earlier in the agreement. And PERS will not approve this JPA agreement without language like that.
Okay.
So it's our plan to submit this with your final approval once we decide upon a name, or you decide upon a name, and you approve the agreement. We would like to submit it to PERS ASAP to get going on that, and feel confident that we likely could meet the January 1st date. I don't think we could ever meet the September 1st date.
Thank you, Mr. Bertram. So let me just summarize what I think I heard, that you need possible direction on the name of the name. Number 2 was whether we become department or an authority. And then, do you need direction from us on dropping on page 14, 11.2D, or is that just procedural?
Assuming the managers have digested that and they agree, yes, I'd like direction.
Okay, and was there any, were the main 3 things?
Those are the main.
Okay, so I think what I'd like to do is open this up to my colleagues to ask questions or comment or clarification from Mr. Bertram, if you have any. Yes,
All right,
please,
I've got a
Diane.
few. Thank you. Tom, the last thing you had mentioned is about sending this on to CalPERS. Can you go over, or maybe this is a question for management, what is the time frame here that we're looking at for approval of the contract by both towns, and of course, approval by CalPERS, and then have it all implemented by January 1, right?
Go ahead, Todd.
Yeah, I think it's there's 2 possibilities. Tom is slightly changing what we discussed at our last meeting, and this has been kind of a moving target, so I think this is something we should definitely vet. From our last meeting, our intent was to bring this JPA before the ad hoc committee today, make any revisions, and hopefully leave with your recommendation. Then to take the JPA agreements to our respective councils the second meeting in August for approval. Again, being contingent as well on the process with LAFCO on receiving that exemption, which Dan is going to research tomorrow. As soon as, after the second meeting in August, when councils hopefully approve this JPA, we would then immediately fill out the application and submit it to CalPERS. Once CalPERS receives that, they estimated that it takes 3 to 6 months, closer to 3 months in their estimate, because we're the only agency going through this application process. Where we would, over a 3-month period, staff would meet with CalPERS to work through the particulars of the agreement. And so with that time frame, yes, January 1st is realistic. In talking to Tom last week, and he mentioned it tonight, it is possible that we may be able to do a different path. And Tom, we should talk this out a little bit, but it would be to take this again. I still think, just from my conversations with CalPERS, that they are going to want our respective councils to approve this JPA. Mm-hmm. Now, whether we go to the Secretary of State and go through that process to form the JPA, because there are questions specific to that in the application, CalPERS may give us some flexibility, but they're going to want to know that the respective councils have approved the JPA, and we can put, and this is for you, Tom, wording in the agreement that we submit to CalPERS that is contingent then on a start date, depending on how CalPERS ultimately rules on what we're trying to do. So I think it's something that we need to definitely vet and talk out, and what you're comfortable with as a ad hoc committee recommending. And I think for Tom also, a process of filing with the Secretary of State, and if we have to change something, what that looks like as well. So I think it's something we need to spend a little bit of time.
Yeah. If I had my dream wish, in CalPERS's interest in approving our agreement is fairly focused on what's going to happen, who's going to be responsible for the plan. So it's not like that they're in charge of or have an interest in or come through our entire agreement. I would really like to get, at least attempt to get a preliminary read or okay from them on the operative language that they're interested in reviewing before going to the councils, scheduling all of that, going through that. So the final agreement that goes in front of the council, that's going to take time, and if we can get in front of CalPERS and just have them look at this preliminarily and get some feedback, that would be my dream wish. If that doesn't work, we can do what Todd was just mentioning, is come to the council and make it a contingency approval. It's really almost a question of what comes first, the chicken or the egg. Is CalPERS really going to insist that the council has to formally approve this, or can they give us an informal read that this looks good or we need to change something? So, go ahead.
I can't speak to that. CalPERS is going to want something formal. They will want a side letter from the labor group stating that they are willing to reform from 3 at 50 to 55 for Corte Madera employees. They will want to see that, and they will want to see that before they will give us any direction.
And we can get that.
And as it relates to the JPA, they will want some formality from our respective city and towns, whatever the governing body is that would review and approve a JPA agreement, which would be our respective councils. They will want to see that and know that before they give us a ruling. I'm afraid that if we don't, as formal as we can be when we submit this to them, we are going to want to check all the boxes, because I'm afraid we're going to go back into the void for a period of months to get an answer. They have been very difficult, and they've been helpful, but it's been very difficult to get a response. They want to see as much formality as possible. And so and thinking about this and talking with Dan and Tom the last few days, I think maybe a middle ground would be to take this to our respective councils, have them review it, have the same conversation, have them sign off on it, and have some contingencies of exactly what we're signing off on.
So that would have to be the next meeting in August, which would, is Corte Madera meet the first week in August? We
Yes,
don't.
Yeah.
We are going to recommend the second meeting in August.
Second meeting in August, because Larkspur doesn't meet the first week in August.
But again, it wouldn't be that we would approve we could put language in there. I think we need to talk that out with Tom to figure that out, but we wouldn't file necessarily with the Secretary of State yet. I don't think that would be necessary, but we'd have some formality where they know the governing body has reviewed it, and they're willing to approve it under these conditions.
Yeah, they're looking for commitment.
So when you mentioned as soon as possible, that doesn't mean tomorrow, that means after the next council meeting at the minimum. Okay. Did you have further? Yes.
Yes, I have a few more. And also, getting back to the LAFCO process, I just want to confirm, I know we talked about this at our last meeting. It is a LAFCO review of the JPA that normally requires a very in-depth analysis. And am I right that what they will be issuing is an exemption from a very extended, in-depth analysis by LAFCO, correct?
That's right. They've transferred it to, it's apparently a ministerial function now. We're going to be the test case. So
Okay.
we'll be crafting with LAFCO how it should work, I think.
Okay, great, thanks. Okay, I wanted to ask about the provision in here for lease of fire stations. I wasn't exactly clear what the wording really means and what the intent was for that paragraph.
Yeah, I think we've learned with the police authority and the stations that we need leases. The leases are a formality. They're for $1 a year. I forget what the term is. It's probably 3 or 5 years. But there has to be some relationship legal relationship between the authority and the owner of the fire station, the city and the town. So that's what that is, a lease.
Got it, okay. And then going on to the termination, there is a, let's see, I think it's on page 15, paragraph 14.2. It provides for a termination effective over 2 years or through a jurisdictional reorganization under California law, et cetera, et cetera. The 2-year termination requires a unanimous vote of the fire council. Can you explain the purpose for that second provision that is under California law? Is that just to cover ourselves if there was?
Yes, and there's all kinds of, that could include, for example, what we were talking about before, another JPA that assumes this one.
Okay.
Or there's some other reorganization, countywide fire agency, something like that. But the real purpose of this is it's a huge hit to terminate this authority once you enter into it. And it takes a lot of time and a lot of effort just to terminate it. And hopefully that never happens. So that's really, the main purpose of this is the time period more than anything else, and a unanimous vote.
Good, okay, thank you.
Thanks. Sloan, anything?
Just a couple of quick
Sure.
things, if you don't mind. Thank you, by the way. And by the way, thank you, Larkspur, on behalf of Corte Madera, for showing the courtesies that you do, as always. We appreciate it. Mr. Bertrand, what code section, in your mind, either prohibits or militates against calling it a department?
I don't think there is a code section. I think it's more a legal definition in case law about what a department is. So if you're asking me, is there something in the Joint Powers Act that would prohibit or preclude?
Or any code of any kind under California? Okay.
Absolutely not. And there's another point I would like to make, which is the police context is very different than the fire context in terms of a police department gets sued on the average. My average client gets sued about 2 or 3 times a month. A fire department, because of the statutory immunities it enjoys, and also because they're not arresting people, they get sued maybe once a decade or maybe once every 20 years. So the confusion and are more pronounced and more aggravated in a police department as opposed to a fire department, but it's the same idea and the same confusion.
Okay. Sort of on that same path then, I wondered what the examples would be. And so one of them is being subjected to a lawsuit by a member of the public, right? What would be another example of confusion caused by calling it a department rather than something else?
Well, some of them may be contractual. A department within a municipality typically for some contracts doesn't have the legal authority to either enter into or bind the municipality, and it would be a city manager that would be doing that.
So if we call it, just to be clear now, so if we, in your mind, there's a risk that if we call it a department, it might interfere with its ability to enter into contracts?
Yes, it could cause confusion as to what this is and where you go to get it approved and who has the authority to do this.
Well, I mean, okay. I mean, with all due respect, that's a different thing, though. Confusion's different from ability. In other words, you mean in a practical way, people wouldn't be used to dealing with a fire
Correct.
department? Okay.
Correct.
But there's no legal prohibition in doing that. It's just a question of ease of doing it. Is that right?
Correct.
Okay. And then, is there anything standing-wise in terms of not just liability to others who are seeking to try to have a direct path to sue our new authority or department, but would it inhibit the standing of our own authority or department to initiate any kind of action other than contractual in nature if it's called something other than an authority or whatever?
It could. I think you could generate a demur in a lawsuit initiated by the authority if you had a name party plaintiff as a department, and the law would not allow a department to sue in its own name. You would have to really unravel that or convince the court or the judge, federal or state, that we're really not a department, that we can sue in our own name, and that we're an authority. And that's where I think Ross Valley kind of flits back and forth between being an authority when they need to and being in a department when they want to. And in speaking to somebody like Gray or even the fire chief of the Ross Valley Authority, one can ask the pertinent question, well, how many practical problems do you really have? How has this impacted you and how difficult is it? Well, I suppose it's like speeding. It's only a problem when, you have a cop behind you and he turns on his red light. And otherwise, you can speed through your heart's content. So at some point, it's my opinion that it's confusing enough and structurally wrong, a structural misrepresentation, if you will. You're actually calling yourself something that you're clearly not. And it would be better if you called yourself something else. If you didn't like authority, call yourself something else. Just don't call yourself a department. And I'm sorry to use this analogy, but I bought my 95-year-old mother recently a very...
I'm really nervous what you're about to say.
A very
It's on tape,
exotic,
too,
a
remember
very
this.
exotic coffee maker, and she never used it, and she likes her crystalline Sanka that she's been drinking for the last 50 years. My point being that, we get used to stuff. We like it, we want to use it, and we're really not going to change. But really what you're doing here is making a structural change. And to try to have it both ways, in my opinion, is unsatisfactory.
I'm sorry, just a couple more
No,
quick.
no, we're not in any
Can I
rush.
ask our friends here in the fire group what they think about alternatives? Let me just preface it. It was my sense at our last meeting, this is a big deal. You want to be called a department. So I want to know how hard to go to bat for this thing.
This is not a make or break issue for us. Tradition is very deep in our department, as in all fire departments. Being a department is what we've all identified with for so many years. I had heard kicked around that there may be a possibility of being an authority, but in name, as we deal with our day-to-day, be a department. I don't know, Mr. Bertrand, if that's legally possible or if that's something that would be totally palatable for our folks. If it was on the patch and on the letterhead, it said department, but
A brand rather than a name.
exactly.
Okay.
Is that being halfway pregnant, or?
That is by the way, that is a terrible
Well,
analogy.
he gave it. Scott?
Showing my age, but it's a step down from, calling yourself purely a department, but I really wouldn't recommend it. It doesn't satisfy my
Okay.
own legal.
Thank you. Scott, were you going to say something?
Yeah, I obviously have to defer to the legal minds in the room. I am not a lawyer, but I was just hopeful that by putting it in the formal formation document that, this is a joint powers authority known as the Central Marin Fire Department. It would, if we get to the point where we're dealing with court or contracts, a simple review of our governing document and a highlight of a section that specifically addresses the issue of name, in my practical thinking mind, should be sufficient. But again, I'm not a lawyer, so
Well,
it's
let
a
me-
preference of ours, but if it can't happen, it can't happen.
Okay, I am an attorney, but painfully aware of my own intellectual mediocrity, and no need to bow down, my friend. I do have one more question, but Diane, I think,
Well,
wanted to get.
let's see if Captain Timmer would
Oh,
like
I'm
to
sorry, I thought.
weigh in.
The goal is to put this thing together, period. So we all would like department. I think we'd prefer it that way. Is it the end-all to be-all? No. I mean, that's the bottom line, really. So from a legal standpoint, we have to do what we have to do and make sure that the document and things that we do are done legally, professionally, that's not going to cause us problems down the road. So like both the gentlemen said, my colleague here, we'd love it to be department, but I don't think that we should let that get us off track whatsoever what we're trying to do here.
So let me just thank you for that attitude. That's a great attitude. I'm sorry, but I do have one more.
Don't be
Do
sorry,
do you
keep
mind?
going.
Because something came to mind, so thank you for letting me butt in here. I'm not an attorney, but I used to be a budget analyst. Would it be possible to set up the authority with two departments? One administration, which covers the council, legal, and finance, and the other the operating fire department that holds all the firefighters, chief, everything else, separate from the council and finance and legal? Just simply as a budgeting structure.
I hate to answer this directly, but I think that would be worse. That would create all kinds of problems for us.
Okay.
Sorry.
Good try, though.
Thanks.
Go ahead, Sloan.
The last thing on a totally different subject, with the arbitration provision or the alternate dispute resolution provision, my own experience, although obviously not in sort of the same field there, is that often you would spell out which arbitration association, like AAA or JAMS or something, and you'd insert that rather than, if the way I read the provision, it sets up a scenario where they presume the parties will agree, and if they don't, somebody else has to pick. But if they can't agree on the arbitrator, why are they going to be able to agree on the arbitration association?
That's a fair question. I think not putting a specific service, ADR service, into the agreement is based on a lot of my clients' past experience. Everybody had AAA for a long time until they got this crazy fee schedule, and now it costs more than any case is worth to use the American Arbitration Association. So they are fast going downhill. Another ADR or alternative dispute provider is JAMS. Everybody is kind of getting a little unhappy with them. The one that I used for the prior police department is a Marin County dispute resolution provider that did a great job. But I think to put one provider in there, the way they change and their fee structure changes and everything, and I can guarantee you that if I'm your legal advisor, you won't have a problem with picking a provider if it ever comes to that remote contingency.
Okay, I mean, we have all come across the occasional attorney who's not reasonable or rational, though, and it can leave everybody in a bit of a morass if there's no path in the event there is no agreement.
Well, that would have to be either your town attorney or your city attorney, and I have full confidence that they're reasonable and rational in doing that. I mean,
Excellent.
Did the managers want to weigh in on that at all?
Whether our attorneys are reasonable and rational.
No, but if you're, it's not our own people, it's that being subject to, you can't stop a crazy person from suing you, you just can't. And that they might hire a crazy lawyer, and you can't stop a crazy lawyer from being crazy. But if you can engraft a provision that provides an alternative in the event crazy people are acting crazy. And that's why I say if you've pre-selected an arbitration association, it allows for the party on the receiving end or on the giving end, whatever, to at least start to walk down the path, get what you might call a default or something if the other side is unwilling to agree. But if the provision isolates out and requires as a condition precedent that you reach agreement before you take the next step, and the other side's not agreeing, you can never get out of the box.
I think that as a general proposition, you're correct, that anybody can sue anybody, and gosh knows there's a lot of crazy, unhinged lawyers out there. I'm just making the point that this is between the town and the city, this ADR process. It's just limited between those two, and I'm sure the town and city attorney can agree on an ADR provider.
Okay.
All
Thank you.
right, do you have questions?
Yeah, I want to go back to the thing about the authority department thing, and because I will try and go to bat for these guys. Do any of you actually know my real name?
Oh, no.
Okay, the point here is that you didn't say that this was required, that it was a recommendation on your part. And the reason why I bring that up, besides the fact that somebody tried to present, an example using a DBA, aside from that, if part of the whole thing is to avoid confusion, people are already confused just by the experience we have with Central Marin Police, because a lot of times they'll approach the city first, and then they go to the authority. It's simply a matter of telling them, we're not the legal entity. And in my situation, you remember how we all got sued one time? And they started to name council members and the whole thing. Well, when they got my name wrong, they just sent it back to the attorney and said, the name's wrong, you got to put the correct name on it. So I guess what I'm getting at is that you mentioned that it was recommended and it was more to avoid confusion. But I think at some level, if the JPA agreement, for example, is stated Central Marin Fire Department, comma, a joint powers authority, whatever. Because you said, well, don't call it something you're not. Well, if we then go down and call ourselves a district, we're not a special district either. So, that's not an appropriate label. So I guess at this point, I'm kind of grappling with other types of legal situations aside from what we call ourselves, how that is worked out in other business-related, circumstances.
Well, using your analogy, I don't think chew carries with it some specific legal connotations, whereas department does. And so there is, I don't know, what is it everybody says with Donald Trump? Words matter. I think that words matter here. And department has a definition, and it's what we're getting away from in converting ourselves into something else. So by the same token, in turning your logic around, I realize that everybody likes department and is used to department, and it has some historical meaning and stuff like that. But other than that fact, that everybody's used to department, I don't know what positive benefit the word department imbrues to the situation, other than it has historical implications. So again, I want to make really clear that I'm your lawyer. I make legal recommendations. You make the decision, and that's all I can do. And my feelings aren't going to be hurt. And I think these gentlemen have very graciously and generously met us more than halfway. So I pass this Gordian knot on to you with alacrity.
Okay. I got a couple other questions on the document itself. In 14.2, in the dissolution of a JPA, if we were to add another entity, much the way we did with Central Marin, we also dissolved that JPA.
We did. You don't necessarily have to. You'd probably want to. I would think a more likely scenario would be that either somebody would withdraw and there'd be a replacement as opposed to a dissolution. But you're right. You're absolutely right.
Yeah, okay. And, you had brought up with 11.2D that Mr. Gray wanted to have that removed. By not stating that, I guess there has to be some place where the obligation's going to be picked up, so why would you leave it unstated?
Because I think Mr. Gray's point was, because in the preceding section in C, you have such a clear line about pre-existing and then the authority, and it's understood what's going on, that this obligation, this D is surplusage.
Oh, so you think it's just redundant?
Yes.
Okay.
And a little bit confusing according to him. And if he's confused, I'm not going to say I'm confused, but I went back and looked at it, and the agreement works fine without it, so.
Okay, thank you. I have
Thank
no
you.
other questions.
Thank you.
Thank you. My questions have been answered from my colleagues, so I'd like to open this up to anyone at the rest of at the table, if you have any questions of this agreement. Scott and Tom? No? Okay. I guess we don't have very many people in the public, but is there anyone in the public who'd like to ask a question about this agreement? All right. Seeing none, I guess we bring it back to us for some discussion. Unless you have any further questions of Mr. Bertram or the managers about any clarifications. So it looks like they're asking us for direction on three things that I understand. The name, Central Marin, what the name will be. Number two, whether it's a department or an authority, and we've heard arguments on both sides as the options. And three, which was to drop 11.2D. Was there anything else?
No, ma'am.
Okay. Who wants to start? Central Marin Fire? Looks nice on that truck so far.
Could we go maybe agency if people don't like authority? Is it that authority is too sterile and clunky?
You know, I don't think it really matters. In my opinion, they've resolved it. We want to move forward. Authority goes on the legal document. When somebody picks up the phone and these guys show up at their house, they're going to be the Central Marin Fire guys. Or people. I mean, they're not coming in with the name authority or department behind them. And they'll maintain their own history and tradition in many of those ways. So I see it as the formality, and the pros and cons of department versus authority may be cleaner for authority. But the public's going to think of it as just our fire department.
Yeah.
And, I mean, they're not going to think of it as an authority. I think they look at our police as our police department, even though it has a different legal name.
Right.
So,
Can I say something?
sure.
I'm kind of going the other way with this.
Are you?
Yeah.
All right.
I don't know what you got. I think the way to do it is we call it in the legal document, the authority or whatever is appropriate, but that it's branded as a department, and let them have the patches and call themselves a department and use it. If it's going to cause a confusion once every decade, it's a confusion I'm probably willing to tolerate. If it causes some angst when they contract, it strikes me that two parties seeking to enter into an agreement whereby one or both of them receive money or services is the kind of thing they'll work their way around. So that although I'm very grateful to you for your legal advice, it would be my own suggestion that we deviate in that one regard, which is that although we would call it the legal name, the authority in the document, in the same breath, we would say to be known as Central Marin Fire Department or whatever they like.
Yes, Dan.
I've kind of, for the extent that my opinion matters, I kind of agree with Sloan, but I would not mention department in the actual JPA document, if for no other reason, because when I cut my teeth in government in Orange County, authority is a very common term in Orange County for fire. And actually in the Sacramento metropolitan area, it's a very common term. And 20, 30 years from now, you may have a bunch of firefighters who think authority is a normal name. I mean, I think what we want to brand the organization as could just be live outside the document entirely. I was actually flipping through Marine Clean Energy's documents trying to remember, because they've never legally changed their name. They're actually the Marin Energy Authority.
No, they're
Right.
now they're now Marin Clean Energy. I was part of the committee that changed it from the Marin Energy Authority to
See, I find
Marin
that
Clean
that's
Energy.
interesting because as a JPA member, I don't remember us ever signing that. So-
We'll leave that for a different conversation.
Did I say I was a part of that? What I meant was that I witnessed that happening
They
from
should update
afar
their website.
and would have liked to have been more involved in that decision-making
I
because
think it's
I'm all
neither
about
here nor there.
transparency.
I would not be shocked if they're still
So you don't delete your
incorporated.
tweets.
My
Yeah.
point is what you're incorporated with the Secretary of State. And everything we sign can say one thing, and the guys can put what they need to on everything else, and we'll probably be all right. I think they'll still serve people calm an authority, and I think they'll still serve people calm a department.
Yes, yeah.
And if I could just add, we're well along in the development of the patch design and the logo, and you'll be happy to hear that it actually just says Central Marin.
Central
So
Marin Fire?
It doesn't even have fire on it. It's just
Wow.
obvious that it is fire because of the crossed axes and the Maltese cross, but, yeah. We thought we'd just avoid the issue.
Scott, I thought if you had your druthers, you wanted department, though. Is that not true?
If I had my druthers, I did, but as all of my colleagues are saying, it's not make or break. What we want to do is consolidate. If we have to be an authority, we're an authority. We don't want it to hang up anything.
Yeah.
So it's not the end of the world, it's a preference. And I do very much appreciate you going to bat for your perceived strong preference, which we
Well, I mean,
have,
but it's not just that. It's for the benefit of our people.
Right.
We want our fire professionals to have the highest morale they can. And if we can accomplish that by a name, I would like to do that, not just for them, but for all of us.
I totally appreciate it. And just from a personal perspective, I think, as Catherine pointed out, the public, in my mind, would be less confused if we were called a department. But I know that that's not really, from a legal standpoint, the point here. But it's just a preference. We'll live with it either way.
Do you have thoughts on this, Larry?
Yeah, I was always kind of on the other side of that. I mean, thank you, Tom. I mean, we always take your recommendations seriously. One of the things that I've been grappling with, though, is that since you didn't say that it had to be done that way, is that to me, there's a community identity associated with this, not just for the firefighters. Because I never say Central Marin Police Authority unless I'm talking to a group in this room where it's just us, at the other meetings. Because whenever we talk to the public, it's always Central Marin Police Department.
Oh, I should say Central
Police
Marin
Department, yeah, whatever. But authority never shows up in there because when I started doing that, a decade ago or whatever, when it was Twin Cities, I go, what's that? So despite the fact that, we have a legal entity, if it doesn't absolutely require us to be called an authority, I would like to keep it as a department.
May I respond?
In its colloquial or informal sense.
I absolutely cannot say that there's any clear legal authority that requires that this JPA be called an authority. Dan is absolutely correct that if you go down south, you see it much more often and people are used to it. If you want to keep department in some way, shape, or form, my recommendation would be to call, for example, if you look at the face page, it has authority, and then if you look at page 1, it has authority. But if you turn to page 2 and look at 1.4 where it says new entity name, I would recommend that if you want it, you want to put department on the patches or the trucks or the letterhead or something, that's the place you do it. Shall operate under the name of the Central Marin Fire Department.
Yeah, I'm fine with it appearing like a DBA. So we all know legally what the entity is. But in conversational sense, it may never be referred to it.
Correct. And you're not breaking my heart. And
I
Thank
think
you.
there's a certain, well, Todd, you weigh in on this, but, you know, 50% of both of our budgets, if not more, go to our public safety services. And, you know, we have Central Marin Police Authority. It's, you know, Central Marin Fire Authority is a tandem relationship, so, go ahead, Todd.
May I just add to that? I think would like both authorities to be called the same, and we always like everything to be the same, but I have to tell you that over the 22 years on the police side, we would have died to be called the department. We would have. We actually changed our letterhead to department at one point, and we got in big trouble from Tom on that one when he found out. And the difference is, like Tom said, it's the confusion and it's lawsuits. And did a lot of research in the county with fire agencies, both the county and respective fire agencies within the county. And as you said, Sloan, lawsuits just aren't common on the fire side. And if it was, and so for the police, you can't do it. You can't consider it. It's too, confusion becomes costly because then our attorney is spending money to undo that confusion, causing us a lot of money. And so it's different on the fire side. My recommendation would be similar to Dan's, but as we just talked about, would be on page 2, section 1.4 would be to call it a department, not the authority. I just don't see it as a big issue, and I think when our employees are 100% behind something, it means something, and morale is important, and I think identity and tradition is important. So I am comfortable on the Corte Madera side to call it a department in that context. And if it becomes an issue in the future, well, our fire council will have to consider.
We can still blame it on Tom, right?
Absolutely, and keep in mind, that's Tom's job. Tom has to give us that recommendation, and so, and I totally respect what he's saying, but again, I think being a fire service, we have some flexibility, and I think if we can, we should consider that.
And let me ask you, coming from a previous law enforcement background that did have the CMPA, and our fire personnel and our police personnel work so closely together, do you think that is a key thing we should consider also, that there's similarity in that name structure? Or do you think it really matters to the line, down on the line?
Well, I think there'll be a jealousy between the police and the fire.
Oh.
One's a department, one's
They
authority,
wanna
but
be
no,
department.
I don't think it, I'll tell you that the police staff considers themselves a department. So no, a name is not going to cause any
So,
separation.
Tom, what do you want to weigh in on that? So the JPA, if I'm hearing what I'm hearing, stays as an authority, but on 1.4, the new entity name, it says instead of Central Marin Fire Authority, it says Central Marin Fire Department? Is that what I'm?
The only other entity we haven't talked about is PERS, but I don't think they have a dog in this hunt at all. So Sloan is correct in saying that there is no requirement. Larry and Sloan are correct about that. I can't answer honestly otherwise. And if there are problems, I can live with it, or we can come back. We can amend our names under the Secretary of State procedure if it creates a lot of problems. I really like these gentlemen's attitude. It's a giving attitude. It's a compromise attitude. And the final straw, I guess, is I can always resign. But I'm fine with it. If it creates problems, I mean, I can always resign. But I'm absolutely, I've given you the unvarnished opinion, which is, we can live with it. There's no requirement. It creates confusion and problems. It's not nearly as acute in a fire department as it is in a police department, and I have a much stronger recommendation when it comes to law enforcement JPAs.
Dan, do you have a thought on that?
Well, I would want language that, if you're going to change 1.4, I think you need to say the legal name is authority, so that when the administrators are preparing legal documents, when we're doing interactions with our risk pool, when we're doing interactions with Sacramento, there's no confusion what the legal name of the entity is, the one we filed with the Secretary of State. If you want to put something in here where the word department's mentioned, you should say something about the department, the agency may refer to itself colloquially or something. I mean, I'll defer to Mr. Bertrand to come up with what this should say. But I think this section should not say we will operate under the name department. If it's an authority, that's the name I'm going to use when I'm engaging entities regionally and statewide. And so it shouldn't say turn around and use the word department in your legal documents. I don't have a problem with it saying use department in communicating with the public or something like that. But
So-
I do think it'd be confusing to say we're one and the other, and you should say department on your documents, but your corporation will be as an authority.
Go ahead.
Well, I respect that. I would say instead that I think Tom Bertrand understands what we're trying to accomplish, that the better practice might be to see how would he suggest doing it.
Yeah, I'm fine.
I think you go with authority in this document, but that this document should acknowledge that at times it'll be referred to as a department, so somebody understands.
No, that makes perfect sense.
it's
So how
one of the
specifically would you do
I
that?
like Dan's approach, and I'll think about it and come up with something. But
Okay.
I would say maybe commonly known as, or
Great.
something
Oh,
like that.
that'd be good. Commonly known as the police department. What do you think?
Yeah, I'm fine with that, doing business as whatever. But, Tom, I wanted to go back to a point that you made in terms of the confusion. I mean, you said that it could cost us money. I would think that if there's any confusion, it would be on the part of somebody trying to sue us, and then they would have to go back and refile everything. But what, give us an example. Yeah, so that, exactly. So what are examples of how it would create a problem for you?
Well, first of all, if we initiate a lawsuit as a department and we're not really a department, somebody could demur or attack our pleading as being improper or unjustified, and that could cost us money. And I think I feel that in the end we could unravel it and proceed, but it's going to confuse the court and the judge. It's going to cost us more money. But you have to ask yourself in the proper, how many times are we going to sue somebody? How many times are we going to be sued? I can honestly say, and I represent the Ross Valley Paramedic Authority and Southern Marin and Tiburon Fire District and stuff like that. They're rarely sued because they have terrific immunities. They're not like the police. The police are sued 100 times more often.
The only time I can see us suing somebody is if CAL FIRE doesn't pay us or something, so.
Well, we can use the authority moniker too and be, again, halfway pregnant like Ross Valley and use whichever one we want when we want.
So it sounds like, well, I will have to get consensus here that the use of the word authority in this legal document to make it a JPA, but inserting a paragraph that says can be commonly referred to as the Central Marin Fire Department, not the official name, but can be referred to. Would that be appropriate?
I don't know about appropriate, but I'm willing to do it, and I think it's
What
a
do you guys
good,
think of that?
I think it's a
I
good
think that's
compromise.
perfect. I think that's a good compromise.
Yeah.
You're fine with that too? You guys want to weigh in on that, or?
I think that would be perfectly appropriate. I just want to make sure that everybody's very comfortable because, again, as I pointed out, I very much appreciate your attempt to make sure that morale stays high, but this is not, I apologize if we led you to believe that this was going to be a crusher if we don't get our way on it. It is really not. Everybody will be thrilled to take the next step forward, even if we are the Central Marin Fire Authority. So everyone up at the dais needs to be supremely comfortable with the decision, and it is not going to be a problem for us. So, thank you.
The managers want to weigh in on that idea? Are you,
We're good.
we're good? We're good?
We're good.
Do we need to move? We just,
I don't think we have to move this
do
or
we need to
anything.
do, no.
No. So that's number one, the name, we covered that one. And then we've decided now that it's going to officially authority in the JPA, but inserting, I guess, a line or a paragraph, whatever it is, can be commonly called. I'll let you wordsmith that one. And then the last one was on page 14, which was recommendation of dropping 11.2. Is there anybody, 11.2D, excuse me. Anybody have any comments about that or questions? I think Larry asked one already, so.
It's okay.
Makes sense to drop it to us, so we'll drop that one.
I had forgot, just as a minor housekeeping note, there's a couple of references to the ARC in here. We're going to delete those out. That's not a legally binding.
To the ARC?
ARC, the annual required contribution, that's actually, that term's constantly changing. It's now actually, a lot of agencies don't use it. They use a different term, the AARC. So I don't recommend it actually be in there, and it's not really adding anything. There's two references. We'll just delete out to that. OPEB liability sufficiently covers what the language is trying to capture.
And I agree with it, and I'm fine with that.
Okay. So we're near the end of number 5. Is there anything else the managers or Mr. Bertram would like us to do with direction regarding this draft agreement? Nope. Okay. Now we're on to number 6, other items. Anybody have any other items they want to bring up?
Nice work, Catherine.
Do you have other items, managers, that you want to bring up? And what about fire? Oh, I'll recognize the captain, not the captain, the chief.
It's not a new item. I just am looking for clarity in my own mind what the decision was in terms of chicken and egg and how we're going to approach the next steps. Are we going to form the JPA and then apply to PERS, or are we going to commit to forming of the JPA if and only if PERS approves our application to reform the retirement? From a personal
Yeah.
perspective, I was excited to get the JPA formed and move forward as a single entity just from our operational perspective, and hope to accomplish the retirement reform downstream, but if it has to happen in the other direction, so be it.
So you want to answer to that?
Probably the most important thing for forming the JPA is not registering it with the Secretary of State, but having both councils approve it and have the mayor sign it. And then that's the agreement. And what I would like to do is send that to PERS before I file it with the Secretary of State, just in case, so we're not doing a lot of amendments. So that would be the process.
And during that next 3 weeks until we have the next council meeting, would it be good to get the letter that you had recommended from fire in support of it and everything?
Yes, and I think that'll be readily forthcoming.
Okay. What do the managers think about that as a strategy?
We were just double checking the actual application with PERS, and the way it's written, I think what Mr. Bertram's recommending makes sense. They sort of acknowledge you may not have filed with the Secretary of State when you make this application. But what Todd's pointing out is it still does say you will have identified who your governing board is, so including its members. So when we approve the JPA, we'll need to have the two councils appoint, I think, convert the steering committee into the first
For now.
board of the council or something. But we can use the PERS application as our guideline of what we have to do. Sorry, that's presumptuous. Maybe you're a fellow.
I'm just messing with you, it's fine.
I think we could just use this application as a guideline of what has to be done to turn it in, and only
Okay.
do those decisions. And I agree with what's being recommended, because it seems to know you may not have yet filed with the Secretary of State.
So it sounds like getting a more complete package, the better for PERS. So having this approved or discussed by both councils and signed by the mayors, and getting letters of support from fire, et cetera, is the next plan.
I think agendizing this and having it approved and executed by each respective council and mayor is the big time suck. if you will. And the sooner we can do that, obviously, the more likely we are to meet our January 1st date.
Okay. Diane?
Now, earlier in this meeting, we were talking simply about approving the JPA pretty much in principle with a list of contingencies we wanted to see, and having the council sign off on that, but not actually adopt the JPA. Now you're saying you actually want us to adopt the JPA and have the mayor sign off on the JPA or on a letter certifying we agree in principle?
I'll take the blame for that confusion because I was articulating my dream wish, which is different than reality, which is can we just send this agreement in its draft form and say it's been approved in principle, and is it okay with you relative to the little part that you agree? But they will not do that, and Todd is absolutely correct.
Okay,
So I'm sorry for that confusion.
that's all right, okay. Good, so.
And you think it should be agendized and not just on the consent calendar, but discussed on an agendized item, it sounds like.
Well, I have a total full faith and confidence that you each could go back to your councils and carry the day immediately, but it's a pretty, I probably would recommend agendizing it.
Okay, so are we
Do you-
clear on that,
Todd,
this
do you guys
process
have a-
going forward? Scott, does that clarify your question about the process going forward?
Yeah, it does. I'll meet with the managers about what it means in a real-world, practical sense to the fire department, and
Okay.
we'll take it from there.
Is there anything we can anything you need us to do up
No,
here?
You guys have been great.
Okay. All right. Anything else the managers want to bring to our attention? Well, that means we're adjourned.
Thank you.
Boom.
Well done.